Okay, so we're going to go on with Lecture 2, talking about the human rights regime. And again, there's three key components to establishing any regime, and they are establishing a body of international law, establishing intergovernmental organizations that govern those laws, and then establishing non-governmental organizations which act as watchdogs. So you have the body of law, you have IGOs like the UN or other that establishes the courts, and then the third thing you have are non-governmental organizations, NGOs, Amnesty International, for example, that acts as a watchdog and can move more fluidly between states and aren't bound by those issues of sovereignty and territorial integrity. All right, so we'll just start with the body of international law. This is that institution building phase that the Bergenthal piece talked about, as well as the phase one that my co-author and I talk about in our article about The Empire Strikes Back. So, after World War II, the UN began to address human rights concerns for obvious reasons, the Holocaust, and other human rights atrocities. So the Universal Declaration of Human Rights, the UDHR, was adopted by the General Assembly of the UN in 1948. And remember the last lecture on international law, we talked about the General Assembly of the UN, and this is just a declaration. It has no force of law, but it is communicating to the international community the global concerns about universal human rights. Okay, these were reinforced with the passage of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. So together, these documents are referred to as the International Bill of Rights. So you have the UDHR, and then you have the International Covenant on Political and Civil Rights that went into force in 1976, and these cover what we talked about before as first-generation rights, and this is the covenant that deals with the right to voting, the right to civil rights, those types of things, and was championed by the West, if you will, during the Cold War. And then you have the International Covenant on Economic, Social, and Cultural Rights. These are those second-generation rights. So if you need a refresher on these types of rights, you'll need to go back to module number 1. All right. Well, let's talk about more specifically this UDHR for a moment. Again, this is not international law. It's a resolution of the UN General Assembly and was not submitted for signature and ratification by member governments. It's more of a mutual admonition to promote the enumerated human rights rather than a formal obligation to do so. Nevertheless, it's still considered important. It builds on the principles of the UN Charter that was just passed before this particular declaration, and is a primary document proclaiming the standards and norms of human rights. And this starts the building block of putting together the human rights regime. The Declaration recognizes the universality, indivisibility, and inalienability of rights on the foundations of equality, freedom, justice, and peace, i.e. those are values. So remember, Donnelly talks about the universality, the indivisibility, and the inalienability of rights. And again, I refer you back to module number 1. It's also important because it signals the international community's willingness and desire to address human rights from at the international system level, and provides for direction on the pattern and content of international law to come. It's also used as a yardstick in measuring the observance of human rights around the world. So it really sets a standard, if you will. All right, let's talk about the International Covenant on Civil and Political Rights. If you Google that, you can come up with a lot of listings about the covenant. You can read the entire covenant, and you can also look at all the different countries that have ratified it or in some form or fashion dealt with this particular covenant. So 167 countries have ratified it. That means it has gone through their domestic process of how a treaty becomes a law in their state. Okay, it emphasizes the individual rights primarily, kind of think of those Lockean rights of individuals against arbitrary governmental power. It emphasizes the equal protection of the law and citizens' rights of participation in the polity. So it really focuses on that individual component. And it builds on the 21 first articles of the UDHR. There are going to be rights that are protected by the non-derogation clause. What does this mean, non-derogation clause? Non-derogation clause is considered universal in terms of the rights. These types of rights are considered universal in substance, form, and interpretation, if you will. So there are certain rights that the covenant permits governments to derogate from. That means reduce their human rights obligations in situations of public emergency. However, it fences off or cordons off a number of rights that even when states are in the grasp of some type of national security emergency, there are no exceptions to. So states cannot suspend or reduce the following. They can't derogate the following. So these are the rights that are part of the non-derogation clause. The right to life in Article 6. Article 7's listing and explanation of the cruel and unusual punishment, including torture. Article 8 dealing with slavery and servitude. Article 11 that says no one shall be imprisoned merely on the ground of inability to fulfill a contractual obligation. There's kind of think of that as debtor's prison. We used to have that in the states. Article 15 talks about no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense at the time when it was committed. This is known as a no ex post facto law. And this should have been covered in your American government classes, but ex post facto basically means you can't be hauled into court today to be convicted of a crime that you committed 10 years ago if that crime didn't appear as a crime back then. Okay, that was pretty convoluted, and let me try that again. Let's say you're driving down the street and you cross through an intersection. Okay, there's no indication that you had to stop or yield or nothing. All right, so you went through that intersection. 2 weeks from then, they put a stop sign in. All right, so they go back and look at, let's assume that they had some sort of recording device, and they see that you went through that same intersection before there was a stop sign. Well, they can't now come and give you a ticket for not heeding the stop sign because it didn't exist at the time. Okay. Another example of an ex post facto law from pop culture, if you will, not pop culture, but legal culture, legal history. The Manson murders. All right, Charles Manson is in prison in California and will be there until he dies for the crimes he committed in the 1960s. Okay, so if you're not aware of the Manson murders, then again, you can Google that. He will never face the death penalty because at the time of his conviction, there was no death penalty allowed in the state of California. So you can't go back in time and submit someone to a crime that wasn't on the books. Okay, so this is what this Article 15 talks about, that you can't be held guilty of a criminal offense on the account of any act or omission which did not constitute that criminal offense at the time when it was committed. Okay. And many people use this defense for those on trial at the Nuremberg trials, the war crimes tribunal after World War II. They're saying, look, you can't, there's no crimes against humanity, but the International Tribunal made arguments that no one could have conceived of these types of crimes. So it kind of ignored this idea of no ex post facto laws. All right. Sorry for the convoluted discussion there. All right. However, if there are times of national security, these are rights that are subject to the escape clause, if you will. States that are party to the covenant have preserved as much as possible their traditional sovereign prerogative to subordinate any international obligation to their national security needs. So if they believe that there's a national security need, they can they can make an argument that those international agreements are subordinate to their domestic concerns. Okay, this of course is defined unilaterally by the state on its own behalf. Okay, so by this escape clause, national governments have allowed themselves, with respect to a wide range of rights, to take back legally with one hand what they have legally given to their constituents with the other. Okay, So you have a potential as a state to retract the right of self-determination. If Texas wanted to secede on the rights of self-determination, the United States would probably squash that and say, we're suspending that right because of national security. Article 8, Section 3 talks about the right not to perform forced or compulsory labor, but we can put people to work on certain types of national security concerns, all right? Article 9 and 14, the due process, arbitrary arrest. We've seen that has been reduced with arrest because of the war on terror. Article 12 talks about the liberty of movement, the freedom of expression, peaceful assembly, the freedom of association, the right of certain ethnic, linguistic, or religious groups. All right. So although the covenant allows that these rights may be limited in times of emergencies that threaten the life of a nation, for example, the wording of the derogation provision puts the burden of proof on the national government to demonstrate that such limitations are indeed justified by the nature of the threats. The covenant also prescribes some rudimentary machinery for implementation in the form of the United Nations Human Rights Committee, and they have a mandate to receive and consider human rights complaints from states regarding the actions of others. So you could bring a state to the attention of the United Nations Human Rights Committee. Okay, again, I have to say, despite efforts of monitoring by the UN, the legal authority to enforce the covenant's provisions still resides almost exclusively in the world's decentralized, sovereignty-protecting system for implementing international law. That is, states are left to govern themselves. The potential help in one way to open up the state sovereignty system is this thing called the optional protocol to the International Covenant on Civil and Political Rights. And this is where a state accedes to the protocol, recognizes the United Nations Human Rights Committee to receive and consider communication from individuals claiming their rights have been violated. As you might imagine, not very many countries have opted for this optional protocol. So again, we can have all this in international law. We can say, look, these rights you can never suspend. These rights could be suspended through this escape clause in times of national security, but you have to, as the state, explain yourself, so to speak. But there's no one really going to do a lot of enforcement. But this was in 1976, and we can kind of see an evolutionary process. And when we get to the end of this module, you'll start to see where people are advocating intervention when states violate or abuse this type of escape clause. All right, well, what about the International Covenant on Economic, Social, and Cultural Rights? Again, this was introduced in 1966 and went into force in 1976 when they had enough states ratify it. Okay, and again, these two separate covenants reflects the debate or differences in human rights philosophy between the advocates of minimal government and the champions of a more socialist or state-sponsored type of governance. Okay. But this covenant obviously deals with economic amenities and conditions of well-being, and the United States has not ratified or is not a party to this particular covenant. Unlike civil and political rights, most of which the citizens presumably already possess, in which the Covenant on Civil and Political Rights admonishes governments not to violate, many of the rights in this covenant can only be realized if countries can marshal new resources to provide the stipulated amenities. So while the Covenant on Political and Civil Rights really talks to governments refraining from doing things to citizens, this international covenant requires states to provide these types of rights or amenities. Okay. Positive rights enumerated by the covenant include things like the right to work, for example. So again, in order to be realized, these rights require countries to marshal new resources. These rights would require government to actually provide something. So, the right to work. Government agrees to take steps to achieve full realization of this rights in the form of training programs, for example. It's unclear to the extent of choice of employment, particularly how this is limited by one's talent. Market economies might reject the full employment aspect, since in these types of economies there's an acceptable level of unemployment, 3 to 5%, for example. Article 7 talks about conditions of work and fair wages, and a lot of this is due to the work done by the International Labor Organization, the ILO, and this group has undertaken a lot of the interpretation of what this article means. So, for example, a 40-hour work week falls within the criteria of a reasonable limitation of working hours. Article 8 talks about the right to have a trade union. Article 9 talks about the right to Social Security or social insurance. The UN General Assembly and drafters have left each country to work out their own form of Social Security, but there is some minimum standard of health and welfare that society as a whole must guarantee. Of course, we're seeing that now with what's going on in the United States with universal health care. Article 10 talks about privileges for childbearing women as it applies to paid leave. In this country we have paid leave for most women. However, there are some institutions that don't provide that. The International Covenant on Economic, Social, and Cultural Rights argues that that should be a right for women. Article 10, Section 3 talks about the exploitation of children. Article 11 talks about the adequate standard of living. Again, this places burdens both on the obligations of governments and of the international community when it comes to the alleviation of starvation. So we think about the U.S. perspective on this. This would obligate the government, the United States government, if they were a party, to not only to intervene in the domestic market to deal with the problems of homelessness and borderline starvation in the United States, but also, given the relative affluence of the U.S., to contribute a non-trivial portion of its wealth and knowledge to the alleviation of poverty around the globe. Okay. And contrary to popular belief, the United States does contribute to world food programs and other types of institutions or organizations aimed at alleviating poverty, but this would bind them to that. And so the question is, shouldn't we do this, especially if we want to make the rules of the international system, or should this be something the United States not be a party of, saying that this is the domain of domestic politics? For us, there's not a right or wrong answer. This is going to be your perspective on these things. All right, Article 12 deals with the right to health and health care. Again, the controversy between those who look toward an activist state to tend to the well-being of the citizenry and those who want as little interference as possible with the free market. And again, the universal health care fits right into this argument. Article 13 and 14 deal with the right to an education. Article 15 deals with the rights concerning culture and science. So again, these are very different types of rights than what we see in the International Covenant on Economic, Social, and Cultural Rights. And again, the United States is not a party to this covenant. But we can also see that there are a lot of other treaties and covenants. So there's covenants dealing with refugees in 51 and 67. There is the Convention on the Elimination of All Forms of Discrimination Against Women. This is called CEDAW in 1981. There's a Convention Against Torture and Other Types of Cruel and degrading punishment in 1987. The Convention on the Rights of the Child in 1990. Again, the United States is not a party to that convention. There's a convention dealing with indigenous peoples in 1991 and migrant workers in 1991. There's regional human rights treaties. Okay, so there is the European Convention on the Protection of Human Rights and Fundamental Freedoms, the European Social Charter. Africa has their charter, the American Convention on Human Rights for the Organization of American States, and so we can see that these are parts of those. The first part of putting together a human rights regime is the passage of international law and charters and covenants that deal with the concept of human rights. Okay. Well, once you have a treaty, you need to implement that treaty. So how is it that these treaties come into full force? And there's usually a two-stage formal process. Okay. And so what we have is a covenant is usually signed by the highest official of the government. So this is the president in our case, but it could be a prime minister. It could be, someone who's considered to be the highest official. Then there's a ratification process by the official that each state has. So a country during this process can attach reservations or conditions. Okay. So countries can attach these things that indicates the provisions which it rejects or what or what it is redefining to make them acceptable to that country's politics, for example. Generally, countries typically tolerate each other's reservations as long as the reservations do not blatantly contradict the main purpose and spirit of the treaty. All right, so there's a lot of leeway here for countries in the ratification process. Okay. All right. Once a party to the covenant, if it goes through the ratification process, and so for us, the ratification process is not only signed by the president, but it has to go through the Senate, because in our situation, 2/3 of the Senate has to approve all treaties. Okay, so that's how that how that process works. So once the state's a party to the covenant, the governments are accountable to the other governments who are a party to the treaty, as well as all those agencies, probably from the UN perspective, or if it's a regional treaty, like in the European context, the EU. And so they have to comply with reporting mechanisms, for example, in order for these human rights to be monitored and to be adjudicated. The ratification process in most countries also makes the covenant part of domestic law, and that's what happens in the United States. So in today's world, one cannot claim that it's part of their state's sovereign practice if it violates the international law. This means that the officials of the government are accountable internally to the institutions of the country for adhering to its provisions. All right. Again, ratification makes it a part of domestic law. But in the end, abiding by human rights international law is highly dependent upon self-enforcement by the parties. Okay, so there's this whole process of putting this international law together. It goes through the formal process of ratification. Countries are all part of this treaty on whatever human rights document that they're agreeing upon. Then when it comes to this issue of enforcement, we're back to self-enforcement, if you will. And this is where IGOs and particularly NGOs come into play when it comes to highlighting human rights abuses. So here is a very scary diagram of the UN. All right, so we can kind of pick apart the human rights element. The UN, in its original conception, was really concerned about war, if you will. So the Security Council and other types of high politics issues usually come through the Security Council. But over time, we can see that this evolution of the UN really tends to focus on human rights issues. All right, so here you see the International Criminal Tribunal for Yugoslavia and for Rwanda. In the Secretariat's purview, there's a Commission for Human Rights, and there's some money and some other resources to deal with human rights. The General Assembly is then kind of another main institution, and you have this Economic and Social Council, and underneath there you have this Commission on Human Rights that reports to these different institutions, the Subcommission on the Promotion and Protection of Human Rights. And so you have all these bodies, all these agencies within the UN that have some focus on human rights. All right, you have economic, social, and cultural rights, the Human Rights Committee, Committee Against Torture, Discrimination, the Rights of the Child. There's CEDAW, the women, discrimination against women. You have some different working groups, and then there's a special committee on Israeli practices in the occupied territories. All right, so all of those highlighted things, and some that should be highlighted, are focusing on human rights. So you can see that the UN's institution has a lot of areas where human rights are the primary focus. All right, so we have all these institutions. How do you obtain justice? You have a human rights violations. What happens? Okay. So we have human rights being internationalized through all this process of institution building. But the question is, are they obtaining justice? Okay, how do you go about obtaining justice? Both within the nation state that has jurisdiction over them, and when some outsiders are willing to deal with the issue as well. All right, but keep in mind the state sovereignty system remains heavily stacked against the ability of persons to obtain redress for human rights violations. So you have a human rights violation, you want something done about the treatment that you're receiving in your state. The state's not helping you. What are some of the methods that individuals use to press their human rights claim? Some include relying upon standard procedures of existing international institutions. Okay, so they can make a claim to the European Court of Justice, or they can make a claim to the American Court of Justice. They can try to embarrass particular governments, and this is where, in today's environment, Twitter and Facebook and other types of social media play a big role. You can support political parties and organizations that can influence legislation and elections regarding the target countries. There's also a whole host of coercive methods that can be used by states to try and change the behavior of others. Economic boycotts like those that were used against South Africa, for example, to try to end apartheid. Work stoppages, nonviolent disruptions of government. Some people will resort to terrorism to try and change government's tactics. And then we have the idea of militarily intervening in a country on the basis of human rights. And this is what the Dowdy and Loescher argument is in Article 3.4, and we'll come back to that a little bit later. Okay. Well, let's talk about some of these international courts. Okay. What do some of these international courts do, and how do we hold individuals accountable? Okay. Well, one of court is the idea, and these courts, what they do is there's a dispute settlement element to any of these treaties. So the WTO, it's an international treaty, and they have some dispute element, settlement portion of it. So if one state's in violation of something about the WTO, there is a committee within the WTO that will sanction another state. Same with NAFTA. But we also have these ad hoc tribunals, the Nuremberg trials after World War II, the Rwandan tribunal to deal with the genocide there, the war crimes in the former Yugoslavia after the end of the Cold War. Those were all tribunals that were put together after the fact to put people on trial for crimes against humanity, if you will. And these courts cover complex international organizations. So you have the International Court of Justice, that's part of the UN. You have the European Court of Justice, that's part of the European Union organization. Okay. But you also have national courts in which foreign defenders can be charged. So you can bring someone to sue somebody basically in court for treatment that you received somewhere else. So let's take a look at some of these and determine whether or not they're all that effective. All right. If we look at this particular website, we can start to look at some international war crimes and justice. All right. So this is an article that looks at whether or not there's progress being made at prosecuting corrupt leaders. So you can look at Gaddafi, for example, and it gives you a history of what was done. Slobodan Milosevic, which is one of the leaders of the conflict in Bosnia and Kosovo, and he was actually arrested by the UN and was on trial in this International Criminal Court. He ends up dying. He was ill before his trial ended. Another participant, Mladic, in the Bosnian army, who is on trial. Another individual from the Bosnian War. Ruto, who was the part of the Kenyan leadership, is on trial for conflict in terms of some of the reported participation in the deaths of Kenyans and displacement of many others. Another individual for the Kosovo wars, and then you have Charles Taylor, who is the president of Liberia, who has been indicted for his role in what happened in Sierra Leone against wars against humanity. This is the KONI, Lord's Resistance Army, for his activities in Uganda. Some other people in the Ugandan case. You have the president of Sudan, who is been indicted. He is at large for the conflict in Darfur. Some other leaders in the Darfur and in Congo. So you can just see that this article is dealing with all these individuals who have been either indicted or being sought after for war crimes. All right, and some of them are still at large, so how effective they are, it requires a lot of international cooperation. So let's dig a little bit more into the ad hoc tribunals for the former Yugoslavia. As part of the UN's website, they have a whole section dedicated to the International Criminal Tribunal for the former Yugoslavia, and you can see it's been going on for about 20 years. So this lists all that's going on about the particular tribunals and whether or not you can actually watch a particular trial. So there are several ongoing cases, and you can sit and watch them on the internet, which can be kind of interesting. All right, so it began in 1993, and the objective is to try cases that dealt with breaches of the 1949 Geneva Convention, genocide, and against crimes against humanity. Now, this probably needs to be updated, but there have been 161 indictments. So the tribunal has indicted 161 individuals, but only 51 of them had been arrested. All right, so here's Milosevic and two of the other individuals, Mladic and Hadžić. I can't pronounce that very well, but it talks about the tribunal talks about their crimes and what they're on trial for. You can go look at the actual timeline provided by. Well, this is an article provided by NBC News, but it gives you a breakdown and talks about the hunt for some of these war crimes suspects. Okay, and we have NATO and other national governments who are on the ground in the former Yugoslavia who have, as part of their jobs, is to capture these suspects and bring them to The Hague for trial. All right. So one thing about these international criminal tribunals is that they take a long time, 19 to 20 years, and even though you have a lot of indictments, that only a third of them have been arrested. Okay. There was a high-profile case of an indictment in a national court. So Pinochet, who's the former dictator of Chile, was indicted in indicted in Spain for some crimes against some Spanish nationals who were in Chile at the time when he was the dictator. And Chile was one of those countries that the United States helped overthrow the government of and install Pinochet. But the Pinochet government was responsible for the disappearances and torture of many citizens in order to maintain power back in the 70s. He went to Great Britain for treatment because he was ill, and Spain wanted him brought to Spain. The Spanish government wanted him brought to Spain in 2000, but Britain refused to extradite him, saying that he was too ill. But however, it did set the precedent that a foreign head of state could be prosecuted if they were to be captured and brought to that particular country or extradited. So this is why a lot of individuals live in exile, go to countries that don't have extradition. All right. The former dictator of Chad was indicted by torture for torture by a court in Senegal in February 2000. And so these are two examples of how a national court, Spain in one case and Senegal in the other, indicted a leader of another country for crimes against humanity. So it is done. But now we have this International Criminal Court. The International Criminal Court is a permanent court that's going to try genocide, war crimes, and crimes against humanity. And this is the Tucker article in your reading. And he talks about the evolution of this process. The International Criminal Court is not a retroactive court. And so one of the big arguments that many people believe is that the International Criminal Court is going to go into the past history and arrest individuals for crimes that are 30, 40 years old, and that's not their mandate. Their mandate is to replace ad hoc tribunals, so it's always going to be in place, so there's not going to be any more ad hoc tribunals after the ones that are already established are over. And they are specifically looking to try cases dealing with genocide, war crimes, and crimes against humanity when and if a country will not deal with those issues domestically. In 1998, it was called the Rome Treaty. It's now signed by, and this needs to be updated, there's far more countries that are signatories, but the United States is not a party to that, and this is what the Tucker article is all about. Okay, and it went into effect in July of 2002. So again, unlike the ad hoc tribunals, the ICC is a permanent court. It's allowed to try individuals, including heads of state, military officers, government officials, as well as private citizens, and it's going to act when domestic courts would not or genuinely cannot act. Okay, and I'll get a new link there. But the ICC has its own website, and then you can go and see in very similar fashion to the ad hoc criminal court for the former Yugoslavia. You can watch what's going on in the ICC online. Okay. Here's the perception of the International Criminal Court. We have some governments that like it, and we have some governments that don't. And so the United States is fearful that U.S. Military personnel will be somehow brought to the International Criminal Court for indictment. All right. Very quickly, we'll just talk about the role of NGOs and transnational advocacy networks. And what NGOs can do is identify and investigate human rights abuses. And again, the example of Amnesty International in Module 2, we looked at one report from Amnesty International comments on what's going on in Russia, for example. So they can investigate and publish those kinds of activities. So all these groups do that. International Red Cross, the Human Rights Watch, Doctors Without Borders, you can add Amnesty International. And so they rely on publicity and political pressure. They were the group that was very instrumental in getting the torture covenant on torture passed. And again, they work as an advocacy organization for those who are in immediate harm and danger. They connect to other networks of other NGOs and try to highlight the abuses of government and bring those abuses to the press and the media for others to then act upon. All right, we'll stop this lecture and we'll have a third lecture dealing with more specifics about the human rights regime and humanitarian intervention.